All right, hey everybody, Curtis Bryan here. Monday, July 28th. We're going to talk today about the quasi-judicial ordinance that is going to be presented to the BOCC tomorrow by Commissioner Kennard. So let's jump into it. So this will take place July 29th, which is tomorrow. This is the overview of the agenda item. So basically, Commissioner Kennard is bringing this to the board to discuss the ex-parte communications and how evidence related to pending development applications are handled. Recommended action down here: direct our county attorney to bring back an ordinance amending our code to adopt an ordinance pursuant to section 286.0115 Florida statutes to amend our code to incorporate necessary changes and to prepare a disclosure form to accompany the new code section. So it sounds like to me that Commissioner Kennard is wanting to change the quasi-judicial rules ordinance in the county, which would then allow ex parte communication to occur and happen, and then that would have to be disclosed to the agenda or to the meeting itself, the quasi-judicial hearing. So why is ex parte communication a problem? So why are we even talking about this today? The reason for this is we've had a lot of land use applications come forward, and they follow what they call a quasi-judicial proceeding. This current Citrus County ordinance basically says that ex parte communication shouldn't happen, and that we shouldn't be having an ex parte communication period, which means that commissioners should not be meeting with developers or having conversations with citizens outside of the hearing itself. The reason for that is you'll hear them say all the time that they are basically judges in the case. So the quasi-judicial hearing, they are the judges. They sit there, they listen to the evidence that's presented. The applicants, which is usually the developer, comes to the board. They bring their evidence of their project. Hey, this is what we're going to do. This is why it fits the comprehensive plan. This is why it fits the LDC. This is why we need this project here in Citrus County. If there's an intervener, that means that someone who's intervening in the hearing as well. Usually it's somebody that's opposed to the project. If they exist, then they are able to come forward and say, hey, this is why this project shouldn't be approved, and provide their evidence and testimony to that effect. The county then has their staff present. The staff presentation is generally a highlight of the land development code, the comprehensive plan, things of that nature, and how this project fits or doesn't fit within that, and then talks about the variances that they're asking for and things of that nature. So imagine for a moment that if the judges, in this case, which being the commissioners, have meetings outside of the quasi-judicial hearing, and they're meeting with developers behind the scenes. And then you come to find out that this project was approved because they met with the developer that promised them this, or whatever. That's not fair to the public because it's considered ex parte communication. And same thing would be true for a developer on the developer side if the commissioners were meeting with a bunch of citizens behind the scenes and they didn't know that existed. So the county has kind of taken the stance of we're not going to have any ex parte communication, but if you have a concern about this, go ahead and email us that concern. We'll put it into the record so that the applicants and the public can read those emails, and then they'll discuss it or not discuss it at the meeting. Problem with that is that we have this Jennings case. So the Jennings case is in 1991. That says that basically all ex parte communication is presumed prejudicial. That means that any email that's sent prior to the hearing, any comments that they have at the public meeting, which happened on May 27th, all of those things that are considered ex parte communication are presumed prejudicial, which means they're not allowed to even have those conversations or even read the emails, technically. How that hurts the county is that going forward, let's say that a developer comes forward, they say that we have this project, we wanted to get approved, that gets denied. Now come to find out there's a bunch of emails and text messages or whatever it is that's part of the record. Those are included in the application process. They come forward and say, hey, the commissioners got 100 different emails about this. They were all anti our project. We want a second hearing. We want to contest this verdict of not getting approval, and we want to appeal that to the court system in a civil case. They can come forward, they can cite the Jennings case saying that those emails were presumed prejudicial, so they shouldn't have even been considered, and that is the reason why they want their case reheard. And there's a very good possibility that that happens. That will cost taxpayers money, more hearings, more of those things, but also legal fees and all of those things. So the Jennings case is what we're currently operating under, which means that zero ex parte communication happens. You'll hear Miss Lynn all the time tell them, even if they get emails, not to read the emails, because that, again, that's considered ex parte communication. But we hear the commissioners all the time say that they read the emails. So there's kind of a very difficult stance to be in here. So we're operating under Jennings. We're operating under the presumption that everything that is sent to commissioners in terms of ex parte communication is presumed prejudicial. So how does this change? So this is what we're talking about on Tuesday. I'm assuming that they're going to bring that something to the board to that effect. We'll talk about that here in a second. This is a video from the Tuscany Ranch hearing. You'll hear Miss Lynn ask them about the ex parte communication, and we'll kind of go from there.
I would ask if you have had any ex parte communications you need to disclose for the record, and we'll start at the end with Commissioner Davis.
Yes, because Metro has never built in this community before, I wanted to see the quality or lack of quality in some of the developments they've already built. So I did some site visits long before the application was made. It was just, we heard through the grapevine that their intent was to build here.
Commissioner Finnegan?
Because there's talk of quasi judicial, I'm going to say yes and just point out that I cannot name any names or sides, but I have read emails, have just heard things in public, read articles in the paper that were both for and against evenly. I couldn't say, but if that's ex parte, I'll just go ahead and throw that out there.
Thank you.
Yes.
Yes, I went and visited the farm because I didn't know I wasn't allowed to. And I saw the operation down there. And I've also had a lot of emails for and against.
I've not spoken with them directly, not visited any of their sites, but I've certainly had people reach out, support or hate on them. But I don't know if that constitutes any communication, but it's there.
Thank you. And next.
So we heard them all say, all five of them said they had ex parte communication. That is the first time I've ever heard all five commissioners admit to have an ex parte communication. Now, with this particular instance, there's a 0% chance that Tuscany is going to appeal this decision because they got it approved. Now, that's not to say that a citizen, someone who's affected by it, someone who spoke at the meeting couldn't appeal the decision based on the grounds of having prejudicial ex parte communication. But that's very unlikely because of the cost associated with doing that. I talked to a couple people and they said they weren't interested in pursuing that because it's going to be too expensive for them, and they fear that it's going to end up in the same situation where they vote for it anyway. So we heard that they all had ex parte communication. Also, you heard Commissioner Davis bring up there that she went and visited the site to see the quality of the construction, all of those things. Important to notice with that, and with other emails and things of that nature, when they bring those to the board and later on in the hearing we heard references to the quality of their development by the commissioners, that was never mentioned by anybody as evidence. So that wasn't mentioned by Metro, that wasn't mentioned by anybody. So that was something that they had taken from the outside, brought it into the hearing, and presented on their own, meaning the commissioners, which is the definition of ex parte communication. So that evidence should not have even been considered as part of their process of talking through this case and listening to the evidence. Now, this is what the Pasco County has done. So there was reference to this in the agenda item by Commissioner Kennard. He references the Pasco County Ordinance here. So basically what they're saying here is that in order to satisfy the Florida statute and remove the presumption of prejudice arising from ex parte communications with local officials, they're going to do the following things. A, the subject of the ex parte communication and the identity of the person, group, or entity with the communication took place is disclosed by the local public official and made part of the record before the final action on the matter. This means that if a commissioner has an email or a conversation with somebody or whatever it is, they will disclose that as part of the record in the case prior to the final action on the matter. B, written communications with the local public official relating to the quasi-judicial action are made part of the record prior to the final action on the matter. So this would be emails, text messages, things of that nature. C, the existence of investigation, site visits, and expert opinions by the local public official relating to the quasi-judicial action are made part of the record before the final action on the matter. So this would cover things like Commissioner Davis going out on a site visit. Same with Commissioner Barrick. She said that she went on a site visit as well. So other things, there was an issue previously of one of the commissioners going through and looking at Sheriff's Office data regarding certain communities and things like that in a prior case. So things like that, commissioners would then be allowed to have those communications as long as they bring them to the board prior to the final action on the matter. And then these disclosures on A, B, and C must be made before or during the public hearing at which the vote is taken on the quasi-judicial matter. So that's saying that all of these disclosures have to be presented to the board prior to the action taken in the quasi-judicial hearing. And then the rest of the ordinance here. This was also included as part of the agenda item. This appears to be an example of what they're looking at possibly using to disclose the ex-parte communication. So this would be a disclosure form basically. On here, this is the local official, so the name of the person, whichever commissioner it is that is having the ex-parte communication. This is the date, this is the meeting location and where it took place. These are the other people that are involved, so whether it's a citizen, whether it's a developer, whoever it is, these are the names, phone numbers there. If you're speaking with a expert on a subject, so if it's a land use case and you're talking to a land use attorney, you have a question about something, and you're talking to a friend of yours that's a land use attorney regarding that, so you can put that in there. If you're talking to a building expert, so you can ask about construction, things like that. So this allows the commissioners to get more information outside of what they might get in the hearing from people who are experts in the field, and so they're able to notify whoever it is for this hearing, and they can put that into the disclosure form. This is the application, so whatever application is being heard. This is the county staff contact person, so this is someone in the land development area, so usually it's Joanna Cotu, sometimes it can be Eric Landon, whoever works in that department there. These are the disclosures of specific topics that are being discussed. This is whether they're talking about traffic access. A lot of that you'll see in a lot of these developments, the big things is about roads. We have too much traffic here. What is the development going to do about roads? So maybe the commissioners are talking about roads. Maybe it's a concerned citizen that is saying, hey, we're having too much building here, there's too much growth, we want more space for parks. So maybe that person wants more park space and they're talking to the commissioner about parks. So this allows the commissioners or the public official to disclose what topic it is that they're talking about. If there's any written materials, those written materials would be provided. So if somebody put together a booklet or whatever, those would be provided to that. I would like to see them go a step further and include a summarization of these things here. So rather than just checking off, yeah, we talked about traffic, that doesn't give anyone an insight into what that conversation was. Part of the issue with Jennings is that the ex-parte communication, if it's not disclosed in full, nobody can contest that ex-parte communication. So we can't overcome that prejudice. So I think that they need to go in depth of these conversations. Hey, we talked about traffic access. The developer said this. The developer said this. I said this. This is my concern. Give us a summary of what that conversation was, more than just, yeah, we talked about traffic. So that way the public or the developer can get in there and be like, hey, we had that conversation, or we saw that conversation, read through the conversation, we have issues with that because of this. And so it allows them to address those types of things. But this is a step in the right direction, I think, having some type of disclosure form. But again, I'd like to see that a little bit more detailed and make it to where if the commissioner wants to have ex parte communication, make it to where it's difficult for them to fill these out in a sense. And I say that to limit the amount of ex parte communication they're going to have. Because if it's kind of a process for them to be able to fill this out, they have to remember the conversation, all those things. If they're required to do all of that, they're not going to have hundreds and hundreds of conversations with people because they have to do one for each of these. So make it a little bit, not easy to do, so that it discourages the commissioners from having to do this for that. So this would have solved the First Amendment issues that we saw on May 27th. So if you're not familiar with the May 27th hearing or the BOCC meeting, basically what happened there was a bunch of citizens got up. They were talking about a pending application and their complaints about that application, and they were silenced by the board. The board continually said that, hey, you can't talk about that. That's a pending application. You can't talk about that, and silenced those members from speaking about that. I did a separate video on this. It's the First Amendment issues that I think the board had violated the First Amendment of many of these people by silencing that speech. But if they adopt this ordinance, and if it adopts the way that it sounds like it's going to, where they allow the ex parte communication with the disclosure, that would then allow citizens to go to a board meeting, whether it's the one for the quasi-judicial hearing or whether it's another board meeting, and make their voices heard on those issues. Sometimes people can't attend the land use case itself because it's too late in the day, or they're on vacation or can't make it, or whatever reason they can't make that particular meeting, but they might be able to visit another meeting to make their points heard. So this would give that citizen the ability to talk about the case outside of that quasi-judicial hearing. So citizens would be free to be able to talk to commissioners about any pending project. That is a pro on this because people want to be heard. Commissioners are also on record of saying that they want to be able to hear from the citizens. They want their input. They want their thoughts on different things, particularly with developments and things of that nature. So this would allow the citizens that ability to, and that access to be able to have those conversations with commissioners, or just go to a meeting and say, hey, we don't like this, or we like this, or whatever their opinion is on that particular case. The downside to this is that developers would also be free to speak to commissioners about projects. So it goes both ways. So if you have citizen input, then you also obviously have developers that would have to be able to give their input as well. So you can't just make it all citizen driven. You can't just be like, hey, citizens get unfettered right to talk to commissioners and the developers can't say anything. So we have to give the developers an equal opportunity there to have those same conversations if we were to open that up to them. So it kind of creates some problems on both sides of things. Also take for a moment, think about this. What if a developer had a meeting? I knew they had a meeting, and then I tried to get a meeting, but the commissioner said they were too busy or what have you because of lack of time or whatever it is. But I know that the developer got a meeting, or vice versa, or the citizen got a meeting, the developer didn't get one. So there's going to be issues on both sides of that. So there's ways that they have to come up to address that. But kind of something to think about. Now, my suggestion to handle this is to, number one, do the ordinance, make the disclosure form, use that form, but make it, like I said before, make it a little bit more expansive, make it a little bit more information so that the public can see specifically what the commissioners are talking about rather than, they're talking about traffic or parks or schools or whatever it is, just with a check mark. Make that conversation a summary, make it more in depth. Give us something there for that. So my suggestion is to do kind of what St. Augustine did. And that is they passed an ordinance back, I think it was 2002 when this went into effect, that said, yes, we're going to pass an ordinance that removes the presumption of prejudice with ex parte communication. So that means that if a commissioner or a public official was to have ex parte communication, we're going to remove that prejudice from the Jennings case by passing this ordinance where they have to do the same things we talked about. So they have to disclose it and all those things. But they went a step further, and they said that they wanted this to be done for the inadvertent communications from citizens who might be unaware of the implications. meaning that a lot of citizens, they don't know the quasi-judicial process. They don't know that, commissioners aren't supposed to talk about a project. So they might see them in the grocery store and say, hey, I like this project, I don't like this project. They might go to the BOCC meeting and, say their opinion about the project at the BOCC meeting, not knowing that there's another process that's going on here. But further, so not only do they allow the ex-parte communication, they're also acknowledging the presumption of prejudice, and this eliminates the presumption of prejudice. But more importantly, they're discouraging the city officials, the county officials, from having those conversations. They're saying that it is the policy of the city that ex-parte communications in quasi-judicial matters are to be discouraged. All members of any board of the city are requested by the city commission to discourage any such ex parte communications and to advise any person making such ex parte communication relating to a quasi-judicial matter to provide such comments either at a scheduled hearing or in writing through the office of city manager. So they're saying that, yes, on occasion you might get a citizen that doesn't know the rules, that doesn't know the process, gets up at the board meeting, gets up in the store, whatever it is, talks to you about the project. They're going to say that shouldn't be considered prejudicial. So this ordinance will remove that presumed prejudice from that. But they're also saying we don't want it to be a free-for-all for our city managers or city commissioners to just have meetings all the time, go out and talk to developers, talk to citizens, just willy-nilly style, talk with everybody and everybody. So they're saying that they should be discouraged. So commissioners, in this case, if the Citrus County was to do this ordinance and copy the St. Augustine method, they would say, hey, board meetings, you have the ex parte communication, we can't stop you from doing that. So we can discourage it. So we can say, hey, you're not supposed to talk about this, but you're talking about it, whatever. But more importantly is that the commissioners are discouraged from doing that on their own. So no single commissioner, while they have the ability to have those meetings, they would be discouraged from having those meetings on their own. So it gives them the ability to say no to those meetings, be like, hey, we're not supposed to talk about these. I'm not comfortable having this hearing or having this meeting prior to the hearing. So let's not talk about that project. If you feel you have something to say, go ahead and email it to us for the record. And so then that would be then put into the record as part of the emails like they're currently doing. But again, importantly, it would remove the presumed prejudice from those emails. So that's the way I think they should go with it. I think that they should adopt the St. Augustine method or something similar to where it removes the prejudice from the ex parte communications, so that way citizens aren't silenced at meetings if they want to get up and speak. That meeting speech then can be put into the public record, disclosed to the public, disclosed as part of the meeting. Same thing if someone talks to somebody at the grocery store or what have you, those can be disclosed for the record. But then it would discourage the commissioners from going on their own and having their own meetings outside of the quasi-judicial process. Now it is possible that they would still have meetings or be able to have meetings at that point because none of them are having them now, presumably. So it does open that door to where they are able to have those meetings with developers or citizens or a combination of both or what have you. But I think that if we strongly discourage that from happening and have that in the ordinance that they're strongly discouraged from doing that, that gives them an out so that they can still continue to go in with we can't talk about these matters, or I'm not comfortable talking about these matters, I don't want to have a meeting with you to talk about these matters. They can still continue with that. They don't have to have those meetings. So that's where I think they should go with it. We'll see what the board decides on Tuesday. Hopefully you guys are there to make your voices heard and give your opinions on that. But feel free to let me know what you guys think, and I will see you guys later.